Alice, you told him to go up to the scene where Mr. Boyd is located with a beanbag shotgun, correct?
I did.
And then you make the statement, I'm going to have you guys come up with a plan, if it's possible before nightfall, to take him into custody for his safety and ours. Do you see that?
I do.
Now, by communicating that statement to Officer Weimer-Skirch, what was the intended effect on the listener?
It's twofold. I'm sending another body, which you requested, more to help. And then I'm also sending up an individual with the tool that you also requested. And then the plan.
Yes, is approximately 4 days.
4?
4.
2.
Guess we're not stopping.
I didn't hear what you said, Your Honor.
I guess we're not stopping.
Okay. My question was just, Judge, do you want to hear the arguments about, I expect they'll have dismissal arguments.
Yeah, I'm gonna have to just wait, have the jury wait while we do this, and then you can call your first witness after the state rests before the jury.
And Your Honor, I know you want to get to motions for directed verdict, but I did have one issue with that I wanted to bring up with Thixton's video before we got started with Mr. Thixton to save time.
Okay, so we can do that after the
Yes.
directed verdict motion.
Thank you.
Any motion?
Well, are we gonna have her arrested from the jury and send her back out and then do the motions? Or, I mean, I just want to hear officially that she's rested in front of the jury. I think that's what's appropriate, Your Honor, before we start arguing why they've missed the boat on their case.
Sure, I understand. So I'll bring them in.
May be seated. Statement called in. Your Honor, at this time, the state of New Mexico rests its case.
Ladies and gentlemen, I'm going to need to give you another recess. I'm not sure how long it'll be, but I appreciate your patience. Please stand for the jury.
Your Honor.
Your Honor, could the court transfer it to the HDMI podium? Your Honor. This is just to aid in the discussion here. Your Honor, at this time, Mr. Sandy moves for a directed verdict with respect to the second-degree murder charge, the voluntary manslaughter charge, and the aggravated battery charge. And we would incorporate our arguments with respect to the double jeopardy motion that was previously filed that the court reserved ruling on. We would incorporate those arguments with respect to the aggravated battery charge at this time. Your Honor, as anticipated, the state has just tried a civil case against the Albuquerque Police Department. They have not met the elements of each and every crime, every element of every crime charged. I'm going to start with the directed verdict standard, and I've posted that law there on the screen for the court to see. Rule 5607E provides that the court shall determine the sufficiency of the evidence. The case law for this, of course, is whether substantial evidence of either a direct or circumstantial nature exists to support a verdict of guilt beyond a reasonable doubt with respect to every element essential to a conviction. So let's look. This comes directly from the state's uniform jury instruction that they've proposed, number 19, for second-degree murder. And as you can see, our dispute here is with respect to element number 4. We do not believe that the state has presented sufficient evidence, either direct or circumstantial, that the defendant did not act in self-defense, defense of another, or commit a justifiable homicide by peace officer. And this comes directly from what the state's proposed UJI is, because as the court noted in State versus Parish and in the use notes to UJI 14-5173, it is actually the state's affirmative burden, if there's some evidence, to prove that the defendant did not act in defense of another. And the state has utterly failed to do that. And I'll go through some of the actual specific evidence here in a minute, but I wanted to show the court the instructions first. With respect to voluntary manslaughter, as the court can see in comparing, this is the state's proposed UJI with, let me go back to the second degree, the only difference between these two is right here, the third element, the defendant did not act as a result of sufficient provocation. I'm going to go back to voluntary manslaughter, number 3, that the defendant acted as a result of sufficient provocation. That is the only distinction between those two charges. Your Honor, if I could approach, we actually do have, and I'd like to file this in open court. It's the written motion for directed verdict on these charges. I'm going to serve a copy of that with the state as well. Can I approach, Judge? Okay, so what is sufficient provocation? Okay. Oh, there's a copy there. I gave you 2, so you have 1 to follow along. Okay. So the difference here between second degree and voluntary manslaughter is sufficient provocation. And our dispute with the voluntary manslaughter is not only this 4th element that's similar to the argument with second degree murder, that the state hasn't proven that they didn't act in defense of another or justifiable homicide, but also they haven't proven that they acted as a result of sufficient provocation. So what is sufficient provocation? The state's UJI number 21 proposed here on the screen shows that sufficient provocation is any action, conduct, or circumstances that arouse anger, rage, fear, other extreme emotions. The provocation must be such that it would affect the ability to reason and cause a temporary loss of self-control. So provocation is not sufficient if there was this cooling off period. So it's a loss of self-control and the ability to reason, an onset of extreme emotions. And looking on to the committee commentary, there are some examples that are given, and these are also in the brief. To the UJI, one is finding a wife by her husband in the act of adultery. that would be sufficient provocation. The act of sodomy with the defendant's young son, that would be sufficient provocation. The other one says a killing to prevent the rape of defendant's wife. Those are examples of what is sufficient provocation. And as the case law here says, sufficient provocation must occur with a sudden anger or heat of passion. And the case law is cited there for the court with paragraph references. So in addition to govern the court's decision in this respect, a voluntary manslaughter instruction cannot be given if the evidence does not support it. The law in State v. Montano, State v. Smith, State v. Trujillo here says it is error for the court to submit to the jury an issue of whether a defendant was guilty of voluntary manslaughter when the facts establish that either first or second degree, but couldn't a conviction for voluntary manslaughter. So let's look at the evidence. There's one more instruction I wanted to point out that I didn't put on here, and that is Rule 11-105 is a rule governing limiting instructions, and I believe that it instructs the court that evidence in the case is limited as to, in other words, evidence that's not admissible against other parties and other people's actions cannot be considered. So this goes to the fact that what the state has proven in this case is, one, there was a lot of officers there, and there were a lot of tools that these officers had. They've proven that Boyd was a threat and that he didn't follow commands, including the command to disarm several times. They've proven that Boyd was going to be taken into custody that night for a violent felony offense. They've proven that officers attempted to have Boyd surrender for several hours and using several different techniques, and he still refused. Their own expert said, direct quote, Boyd never surrendered. The state's proven that it was not Mr. Sandy. Mr. Sandy did not pull off any CIT officers. Mr. Sandy was in fact dispatched to arrive on scene. The state's proven that it was appropriate for the officers to respond with rifles. The state's also proven that at the time Boyd was shot, it was Mr. Sandy's job. This is based on questioning from our side too, but this is what's in evidence. That at the time that Boyd was shot, Mr. Sandy's job in that moment was lethal cover of Officer Weimerskirt's. There's been no testimony that Mr. Sandy did anything wrong in this. In fact, the direct testimony here, it's on the screen. This is from this trial, and I have the transcripts. I think the transcripts are actually attached to the motion as well, Your Honor, as an exhibit, and the state has a copy now. So it says, so the use of force, SOP, we're going through, Exhibit 1, you didn't find any provision that Keith Sandy violated, did you? As far as use of force, no. It was APD's policy for use of force at the time that understands what an articulable threat is. And Mr. Boyd, and he went through here that he presented the means, the opportunity, the intent, which was an immediate threat under the SOP policy. This was also the testimony from Jeff Stone. Mr. Sandy's one and only job on that hill in the evening preceding Mr. Boyd being shot was providing lethal cover. So let's talk about the testimony of Jeff Noble. This is also directly, I don't think this one is attached, but it's from the transcript. This goes, Your Honor, to the issue of how this was a professional, reasonable, calculated decision that was made. It was not an act of sufficient provocation. The testimony has been very clear that the decision to shoot Mr. Boyd was a decision that was made based on their training and experience and the perception that they both independently had. That's very important, Judge, when you're analyzing sufficient provocation, is that two officers who had never communicated that day, that's what the testimony showed, they both perceived the immediate threat and they shot. There's been no evidence that they both simultaneously had this onset of emotion, this sudden heat of passion independently. There's been none, because that doesn't even make sense. It was both a decision, and even Jeff Noble's testimony went to that. So Jeff Noble says, the perspective of a reasonable officer on scene, that's for making the decision force, yes. So this is based on Mr. Sandy's perspective and the decision he made, and it depends on whether or not Mr. Sandy's perceptions, those were, and his ability to perceive. There's nothing about this heat of passion, this onset of emotion, that is necessary for voluntary manslaughter. In fact, testimony of Jeff Noble continued. If he perceived the step, is what he's referring to here, that he wouldn't admit to seeing, but if Mr. Sandy perceived that, then it's not just justified, it's far beyond that, isn't it? It's his sworn duty that he has to shoot, doesn't he? And their expert said, as long as his perception was objectively reasonable, yes. This goes to show that this is, he says, any decision to use force happens at the last second, but decisions don't always get made in a split second. So the testimony of Noble, the case that they've presented, goes to whether or not that was the right decision, but nonetheless, it's definitely not a provoked loss of control, loss of emotion. And the notion that two independent officers experience that same perception at the same time proves that point. Let's go on with what else the state showed. They showed that at the time Boyd was shot, he had presented 2 knives, and he did not follow 4 commands to get on the ground. And that he, at this time that he presented 2 knives and was not getting on the ground after 4 commands, that he was within 9 feet of Officer Weimerskirch, and we heard testimony from the witnesses about the tool or drill and how being within 9 feet of a suspect armed with 2 knives that are already out is an imminent deadly threat to an officer, in this case Officer Weimerskirch. But there was also testimony about what Mr. Sandy perceived, and that was through his statement. And that testimony was that he saw a defensive posture. Boyd drew knives and he was in a defensive posture. And the testimony revealed that defensive posture was an aggressive stance, as if he was ready for a fight, Boyd. That he was squaring off to him. That he was turning to the left as if to flank to get around the dog. And through the testimony, Mr. Sandy's statement was, at that time, I, quote, made the decision. I made the decision to engage him with my rifle, aimed center mass. There's a lot of discussion about center mass. This is not a loss of emotion. This is a decision to shoot based on a perception of an officer who is trained to do exactly that. In fact, Your Honor, Noble was the one who also testified at center mass, because that's also where he aimed when he shot and killed in his previous case. That only further supports the fact that this was a trained, calm, professional action. Testimony of Sergeant James Fox. This reinforces the fact that the state has not met that 4th element on second-degree murder. And that is, if not, this was the testimony that came in through the state's presentation. If it wasn't Officer Perez, it would have been another officer, because they're all trained the same. A cover officer has one job, to keep himself safe and his fellow officer safe. If a cover officer perceives an immediate deadly threat to another officer, SOP and training provides to employ the lethal option. It's their duty. He talked about the training and the SOP that an officer has to stop an attack before it begins, before it happens. And the reason for that, as Sergeant Fox explained, is because of physical lag time and reactionary gap. In fact, this is another further evidence that this was not a loss of emotion, an onset of emotion, loss of control. APD training, according to Sergeant Fox, in use of deadly force is to shoot twice, a standard defensive response, he says. And then you recess. And then, if the action has not stopped, you shoot again, a total of 3 shots. And how many shots were in this case, Judge? 3 each. Each of these officers fired twice standard defensive response, reassessed, they both independently saw the action was not being stopped, and they both shot again. I wanted to talk about the aggravated battery briefly, Judge. Sam Andrews testified that the death was caused by all three bullets that hit Mr. Boyd. There's been no evidence that Mr. Sandy's bullets didn't cause the death. His ultimate opinion, and Ms. McGinn even made this a point in her redirect to come up and reaffirm that Mr. Sandy's bullets also contributed to the death. So based on that, Judge, there's been no evidence that his bullets didn't cause the death. So the proper charge here would be second degree, and it would be double jeopardy to also submit aggravated battery to the jury as well. So in sum, we would ask that if you go back to the standard of whether there is substantial evidence of either a direct or circumstantial nature to support guilt beyond a reasonable doubt of every element, states proposed, they have not proven element 4 for second-degree murder, that the defendant did not act in defense of another. With respect to voluntary manslaughter, they did not prove element 3, that they acted as a result of sufficient provocation, nor have they proven the same element number 4, that they did not act in justifiable defense of another. And again, the standard for sufficient provocation, extreme emotion, to cause temporary loss of self-control. And these are the examples there, Judge. And then the aggravated battery is based on Sam Andrews' testimony and the lack of any testimony that Keith Sandy's bullet did not cause the death. Because if it did not cause the death, it could possibly be an aggravated battery instead of a second degree. So that's the basis for our argument. We'd ask the court to enter directed verdict on all 3 counts. And I'll stand for questions.
That's fine.
Thank you, Judge.
Any motions from Defendant Perez before I turn it over to Steve?
Thank you, Your Honor. May it please the court, counsel. At this time, Defendant Perez respectfully moves the court pursuant to Rule 5-607E to dismiss the charges against him as found in the amended information. Now, I'm finding myself in the unenviable position of having to follow Ms. Garcia. Inevitably, there's going to be some overlap in what I say, but I'll endeavor not to recreate too much of what she's already said. To some extent, I beg the court's indulgence because I do have to create a record, and also because there are some distinct differences in the arguments for Officer Perez versus Detective Sandy. So at this point in the course, at this point in the case, of course, the court has to determine whether sufficient evidence was presented in the state's case to support the underlying charges. You're called upon to evaluate whether substantial evidence exists to support a finding of guilt beyond a reasonable doubt with respect to every element essential to a conviction. Certainly, I understand the difficulty of this task, especially in such a high-profile and controversial case. But unless you determine that a rational trier of fact could find each element of the crime beyond a reasonable doubt, then the charge must be dismissed. And I'd like to start first with the voluntary manslaughter charge, the lesser included offense. Now, as Ms. Garcia alluded to, the additional element that the state has to prove in order to support a charge of voluntary manslaughter is sufficient provocation. And as she alluded to, it is reversible error to submit a charge of voluntary manslaughter to the jury where there is insufficient evidence of that provocation to warrant its submission. And looking at the way in which sufficient provocation is defined by law illustrates exactly why voluntary manslaughter is inapplicable to the undisputed facts of this case with respect to Officer Perez. As we talked about before, a defendant may be charged with and convicted of voluntary manslaughter only if there exists evidence that the killing in question was committed upon a sudden quarrel or in the heat of passion. I believe Ms. Garcia referred to UJI 14-222 defining sufficient provocation for purposes of an instruction on voluntary manslaughter. And just one more time, I'll reference that the UJI defines sufficient provocation as any action, conduct, or circumstances which arouse anger, rage, fear, sudden resentment, terror, or other extreme emotions. Provocation must be such as would affect the ability to reason and cause a temporary loss of self-control in an ordinary person. And as noted almost a century ago in State v. Kidd, a 1917 Supreme Court case, and still the law today, the provocation at issue must be such as to render the defendant incapable of cool reflection. Now, regardless of whether reasonable minds could differ on whether Mr. Boyd posed a threat of death or great bodily harm to another officer at the time he was shot, there's been absolutely no evidence that Officer Perez's decision to shoot Mr. Boyd was the result of a temporary loss of self-control or inability to reason. Not one witness provided any evidence, either direct or circumstantial, that Officer Perez's actions in deliberately shooting Mr. Boyd upon seeing him standing over Officer Weimerskirch with knives drawn stemmed from anything other than calm and rational action based on years of training and experience. There was no testimony regarding any anger, rage, or other extreme emotion on the part of Officer Perez, either before or at the time of the shooting. Now, certainly, as Ms. Garcia has already stated, the fact that both Mr. Sandy and Mr. Perez fired essentially simultaneously does speak volumes, because a jury would have to find that Officer Perez was overcome by extreme emotion at the precise time that Mr. Sandy was similarly overcome by extreme emotion in order to convict him of voluntary manslaughter. But with regard to Officer Perez, there's more. The undisputed facts indicate he'd not been on the scene for more than a few minutes. He'd not spoken about Mr. Boyd. He'd not spoken to Mr. Boyd. Not made any comments regarding Mr. Boyd or communicated with him in any way. And he'd not actually witnessed Mr. Boyd previously drawing knives prior to the time that he drew them in the very close vicinity of Officer Weimerskirch. So he hadn't even been aware previously, visually, of having seen him get those knives out, to the extent that even that could be considered a prior provocation. Now, as Sergeant Fox relayed this morning in his very powerful testimony, he specifically chose Officer Perez for this situation because of his level-headedness and his coolness under pressure. He testified that Officer Perez checked in with him and reported exactly where Sergeant Fox sent him. Officer Perez took on the assigned task of serving as a cover officer, and Sergeant Fox says he performed precisely as he had been trained to do and as Sergeant Fox had expected him to. Now, this is the antithesis of acting on emotion. In short, the state hasn't presented any evidence or testimony to enable a rational jury to conclude that Officer Perez was rendered incapable of cool reflection or acted from a loss of self-control, as opposed to acting calmly, rationally, and deliberately. As such, the state cannot meet its burden to demonstrate one of the essential elements of voluntary manslaughter, and Officer Perez therefore respectfully moves that this charge accordingly be dismissed at this time. Now, with respect to the second-degree murder charge, we know that the law governing justifiable homicide by a police officer, as set forth in NMSA 30-2-6 and the corresponding UJI 14-5173, is that deadly force is authorized if a reasonable officer in the defendant's position would have probable cause to believe the decedent posed a threat of death or great bodily harm to another person. Notice I didn't use the word immediate threat, because under the UJI, such a threat need not even be classified as immediate. That distinguishes it from the SOP that we've been talking about the last week and a half. And we know that if any evidence supports Officer Perez's contention that his actions were legally justified, the burden then shifts to the state to demonstrate that his actions were unjustified as an element of the offense. The state has now completed its case. and it has not presented evidence sufficient to meet its burden to demonstrate that Officer Perez lacked legal justification for his actions. Rather than evidence of that, what we have in the state's case are arguments. Arguments that are contrary to the law and to the evidence. Of course, arguments of counsel are not evidence and can't be used to create asserted facts. And I'd respectfully say that, especially in this case, that's a good thing, as we've seen many of the arguments that have been raised by the state in its opening kind of fall by the wayside as the evidence has come in. Instead, the arguments raised by the state about issues such as whether other officers responded in an ideal fashion, or whether in hindsight the shooting of Mr. Boyd could have been conceivably prevented if other policies had been in place, or if other tools or tactics had been used prior to the time Mr. Boyd posed a deadly threat. Those are an attempt to distract from the only question that's relevant as a matter of law to Officer Perez in this case. And I believe you've been very clear throughout in your rulings throughout the case that it's the reasonableness of his belief at the time he made the decision to shoot at James Boyd that Mr. Boyd posed a threat of death or serious injury to another. That's what we're looking at here, not the actions of the others. And yet throughout the case, those actions have been talked about as being part of the totality of the circumstances. I think that you've understood well, totality of the circumstances is applied to the officer at the time he makes his decision versus totality of the circumstances of everything that led up to that is what we should be looking at. And so I ask you to focus on that as you're making your decision here as to whether the evidence is sufficient. For instance, we have an argument that Officer Perez can't claim that his act of shooting was legally justified, regardless of how clearly it may have appeared that Mr. Boyd was threatening the lives and safety of fellow officers, because either he or some other officer was an initial aggressor who created the need to use deadly force. In fact, in its trial brief, the state wrote directly, quote, "A defendant who provokes an encounter, as a result of which he finds it necessary to use deadly force to defend himself, is guilty of an unlawful homicide and cannot avail himself of the claim that he was acting in self-defense." That's from the trial brief, but it shows a very different case than we have here. The state has introduced no evidence whatsoever to demonstrate that Officer Perez himself was an aggressor or an instigator of an altercation in any way. Instead, the evidence has been undisputed that Officer Perez simply reported to his location where he was placed to serve as cover. He was not directly involved in the attempted arrest of Mr. Boyd or the plan to effect the arrest. Nobody has testified otherwise. And Sergeant Fox, the very person who put him in this situation, explicitly made clear that Officer Perez had no involvement in the plan or the attempted arrest. So he cannot, even under what I would contend is the state's misguided way of looking at the case, he himself cannot be considered an aggressor. Nor, no matter how hard it tries, can the state take the focus away from whether Officer Perez's actions were objectively reasonable based on his perception at the time of the incident by trying to point to the actions of others. No case law in New Mexico holds that the defense of another or justifiable homicide by a police officer is precluded by the action of anyone other than the defendant. Because, as we've discussed before, that would put the defendant in the impossible position of having to make a split-second decision of whether somebody in mortal danger could possibly be considered an aggressor and therefore eligible to be saved only at the risk of criminal peril. We know that's not what the law requires. We've heard testimony throughout that even if an officer makes a mistake and puts themselves in a position where they are under threat of deadly force, the cover officer's job is still to cover them. Even the state's own expert agreed with that the cover officer would still have the duty to save them in that condition. Moreover, the UJI that speaks to the effect of being an aggressor, and that's 14-5191, is explicitly limited to self-defense. The committee commentary for that UJI noted that the New Mexico Supreme Court in State v. Maestas declined to adopt the precept that the person using deadly force is in the same shoes as the person being protected when it comes to defense of another, and certainly never sought to apply it to justifiable homicide by a police officer. So even if other people in this case could be considered aggressors in this situation, it should not limit Officer Perez's ability to utilize his defense based on his reasonable perceptions at the time. Similarly, the actions of the open space officers should not be considered when determining whether the state has presented enough evidence. The case law is clear. They had a duty to investigate this situation. They're legally authorized to show force in such a situation if someone doesn't show their hands, and legally authorized to do a pat-down search upon seeing a knife under these circumstances. The state's own witnesses have agreed that Mr. Boyd committed an aggravated assault on a police officer by pulling out the knives. Once he did that, the other officers had a lawful duty to arrest Mr. Boyd for that felony crime and were in the act of attempting to do so. Even Jeff Noble agreed that Mr. Boyd had committed this felony crime, as did Patrick Hernandez, the very officer who was the victim of this crime. So for these reasons, State v. Mantelli, which sets the standard in this state for evaluating whether homicide by a police officer is justified, it recognized that unlike private citizens who can maintain distance and not be the aggressor and then claim self-defense, officers do sometimes have a lawful duty to be the aggressors in the course of fulfilling their responsibilities to the public. And one of those responsibilities was effecting an arrest on Mr. Boyd. So therefore, the state's argument that Officer Perez's claim of justifiable homicide by a peace officer is dependent on whether it was necessitated by Mr. Boyd's reaction to the illegal arrest is not supported by law. Finally, the state argues that Mr. Boyd had agreed to surrender prior to the other officers employing less lethal force, and that he was in the process of surrendering, and therefore Officer Perez cannot claim that he acted reasonably. But there has been no evidence produced in the state's case that Mr. Boyd ever put down his knives or manifested objective cues that he was surrendering. As Ms. Garcia referenced, their own police procedures expert, Mr. Noble, specifically testified he did not surrender. In fact, the undisputed evidence is that Mr. Boyd still held his knives at the time he was shot. Now, the state has been trying to bring up questions as to whether Mr. Boyd was asked to come down the hill, or told he could come down the hill. None of that gets into whether Officer Perez's perception at the time was reasonable, especially because he had no way of knowing anything that had been said to Mr. Boyd beforehand. All he could do was act based on what he was observing. In short, the state can't escape its burden to demonstrate that Officer Perez's actions were not legally justified simply by questioning the actions of others, including what they told Mr. Boyd prior to the plan. It's only his own perspective at the time he made the decision to shoot. Now, the undisputed testimony has shown us the officer has a duty to use deadly force if a fellow officer is faced with the imminent threat of death or great bodily harm, regardless of whether another officer mistakenly created the situation. It's also undisputed that the Albuquerque Police Department's standard operating procedure on the use of deadly force defines immediacy of a threat for purposes of deadly force with respect to a subject's intent, means, and opportunity, and states that such a threat need not currently exist, but may happen within moments, with or without warning. This is precisely the issue that we had here, as was testified to, and as Detective Stone said, yes, intent, means, and opportunity all existed. And it was his investigation that revealed that. At the time of the shooting, Mr. Boyd had the intent, means, and opportunity to carry out a deadly attack on Officer Weimerskirch. This has not been contradicted. The state's case is complete. and has simply failed to come forward with sufficient evidence to allow a rational jury to find that Officer Perez shot at James Boyd for any reason other than an objectively reasonable belief that he posed a significant threat of death or serious bodily injury to a fellow officer. They have not hypothesized any possible other reason that he shot. As such, it has failed to meet its burden on an essential element of each of the charges, and Officer Perez therefore respectfully requests at this time and moves the court to dismiss all charges against him. And I stand for questions as well.
Judge, I know you know the law that the evidence on this kind of motion is to be viewed in the light most favorable to the state and most favorable to a guilty verdict, that it is not the court's job to weigh the credibility of witnesses, and the court doesn't decide whether to disbelieve or discount conflicting testimony or to adopt the defendant's view of the evidence. And in fact, when this motion was heard in the preliminary hearing, the big issue that was raised by the defense was that we didn't have a police practices expert to talk about whether there was an immediate threat or whether Mr. Boyd was surrendering. And in this case, of course, that was our very first witness. We finally found another police officer who would be willing to review this case and testify about what happened, which was a difficult task to do. And he came in and told the court, and so it's clear what he didn't say. What he said was, on cross, he never said he was surrendering, but his actions could indicate that he's surrendering. And that very issue, whether there was an immediate threat, and the issue of whether he was surrendering and following orders at the time he was shot, are both issues for the jury, not for any of the experts in the case. And all of that is proven by the videotape. That is probably the single most important piece of evidence, the two videotapes that we have about whether he was posing an immediate threat or whether he was surrendering at the time. But let me start with sort of backwards from where, in the same order they started. The first thing is voluntary manslaughter. It is the defendant's burden to show sufficient provocation, not the state. And the case in which it says that is State versus Taylor, Your Honor, 2000 NMCA 072. And what that case says is that voluntary manslaughter is a lesser included offense because it's known as imperfect self-defense or imperfect justification. And to place, this is a quote from the case, to place the burden on the state to disprove provocation, defendant must demonstrate legally sufficient provocation. And the defendant is the one who must demonstrate that his anger, etc., would affect his intent in the case. So that burden is actually switched for voluntary manslaughter. But even if we do have the burden, what is the evidence that these officers were suffering from provocation by Mr. Boyd? I'm afraid that was put on mostly by the defense in the case. It is the CADs and the radio transmissions that they put on, both in opening and then throughout their case, that Mr. Boyd was threatening to kill them, that he was threatening to put a knife in the neck of Sergeant Weimerskirch. And even though Defendant Perez was not there, they have put on themselves the evidence that Defendant Perez reviewed all of the CADs before he arrived at the scene and would have been told that this person was threatening police officers and threatening to kill police officers. All of that indicates provocation of the sort that may cause the jury to decide, rather than finding the defendants guilty of second-degree murder, they should find the defendants guilty of voluntary manslaughter. And that was put on by the defense themselves. As for second-degree murder, the issue, all these issues about whether or not it was justifiable homicide, whether they were acting reasonably, all of that came in through both our expert Jeff Noble and through the last witness, Jim Fox, who said it has to be an immediate threat, and you can't shoot somebody when they're surrendering. On the video clearly shows, Your Honor, that Mr. Boyd was turning, not just that he was turning, but in Defendant Sandy's own statement, Defendant Sandy admitted that he saw he was turning to his left, and despite the fact that he was turning to his left to respond to their commands to get on the ground, Defendant Sandy shot him anyway. And then after the 3 shots were fired, it is clear from the video that his back was to Defendant Perez, and Defendant Perez shot him in the back as he was turning to lay on the ground. And there is a dispute in the testimony. The defense wants to argue, oh, he was somehow incapacitated, and that's why he fell to the ground. He wasn't turning to lay on the ground, but I think it is up to the jury to decide that, and the video clearly shows that he was turning to lay on the ground to obey the police officer's orders. And if that's the case, both ends of our case, both Jeff Noble and Jim Fox, say you can't shoot somebody who is surrendering and laying on the ground. As for aggravated battery, Judge, it's not double jeopardy because it has different elements, and I think we've fully briefed that issue for the court. So here is how they could find aggravated battery if they did not find, for Defendant Sandy, either second-degree murder or voluntary manslaughter. They could find that his bullet, despite the testimony of Sam Andrews, that death was caused by a combination of blood loss from both of these bullets. They could find that because they were able to amputate his arm, that he might have survived if not for the bullet in the back. If they found that fact, and I think, in fact, Mr. Bregman cross-examined Dr. Andrews on that very fact, that he might have survived if he just had these arm injuries. If the jury found that, they could acquit on second-degree murder, could acquit on voluntary, which both require his bullet to have caused a homicide, and yet convict on aggravated battery. And because of that distinction, that's why the aggravated battery charge is not double jeopardy and is not a lesser included. Based on the jury's factual findings, they could find aggravated battery and not the other 2. And I think that's all I have, but let me check. Just rather than have him tell me, can I just have him talk?
So, Your Honor, also on the double jeopardy argument, I would just point to the case law that we cited in our brief that it's not double jeopardy until there are multiple punishments. So even if Your Honor finds that aggravated battery is a lesser included offense under the Blockberger test, it's not double jeopardy until the court enters a sentence. So for that reason, the aggravated battery charge should be submitted to the jury. And I believe the case we cited for that was State v. Martinez, 1995 NMSC 064. And State v. Swick, 2012 NMSC 018. I think that was all. And we also submitted a few additional cases to Your Honor during the previous hearing that I would ask you to consider on that point as well. Thanks.
Sure, I have 3 points. With respect to Ms. McGinn's suggestion that the defense has a burden in this case to prove sufficient provocation, that's patently false. The case that she's referencing is in a situation where a defendant is trying to seek a voluntary manslaughter instruction as a lesser included offense, and the state is opposing that. In that type of situation, the defense would have to say, there has been sufficient provocation evidence because we want this instruction. But in this case, it's quite the opposite. The voluntary manslaughter should be directed out, and it is the state's burden as the proponent of the instruction to show sufficient provocation.
Let me ask you a question.
Certainly.
And is your client maintaining his position that directed verdict should be entered with regard to the charge of voluntary manslaughter regardless of my ruling on your motion for directed verdict on second degree?
I didn't.
Is defendant Sandy maintaining his position to the motion for directed verdict on voluntary manslaughter regardless of the verdict on the directed verdict motion with regard to second degree murder?
I guess I don't understand.
I'm not completely.
Okay, let me say it differently. If you lose on your motion for directed verdict, on second degree.
Okay.
Are you going to reserve on your motion for voluntary manslaughter? Or are you,
We still want it tossed. If we lose on the first one, we want voluntary manslaughter no matter what. Yes.
Yes, Judge.
and is it the same for defendant Perez?
Yes, it is, Your Honor. I just confirmed.
Thank you for that clarification.
Thank you, Judge. So that was the first point. The second point I'd like to make is that Noble's testimony was that there was reference to him being a use of force expert, and that was lacking in the prelim. His testimony was, I recall two pieces. One, that this was reckless planning, and then the other was that it was unreasonable. I don't recall any testimony from him, and I think the reckless planning portion is irrelevant to the elements of the crime here. There was no testimony. His testimony was not that the defendants failed to act in defense of another. Noble never said that Weimerskirch wasn't in danger. That's kind of where his testimony stopped short. I think they missed that additional step there. And then finally, my third point was with respect to aggravated battery. Your Honor, Ms. McGinn referenced that Sam Andrews was crossed by Mr. Bregman about the fact that he might have survived with if he hadn't had to have his arm amputated. But the point, he was crossed on that, but Mr. Andrews made clear that he, on redirect, that was not his opinion, that he had changed his opinion. And his opinion is clear that that Mr. Sandy's bullet was a cause of the death, and because of that, aggravated battery shouldn't be submitted to the jury. Any other questions, Judge? Okay.
No, not for you.
Okay.
Your Honor, I think that our position is clear. I don't want to belabor the point, but I do want to respond to Ms. McGinn's case that she cited. As Ms. Garcia said, that is a case in which someone was seeking a voluntary manslaughter instruction. In this case, the state decided to charge it as a lesser included offense. And if you look at the UJI that the state has submitted, sufficient provocation is an element of voluntary manslaughter. And if it's an element that they have to prove, then it's not on us to prove it. So I just want to make that distinction. Anything else?
Not lost.
I believe that.
Ms. McGinn, Ms. Garcia said that Mr. Noble never testified that Weimerskirch wasn't in danger. Do you agree with that?
I disagree with that, Judge. I believe the test was whether there was immediate harm for any of the officers, and he said there was no immediate harm for any of the officers. I asked him specifically that particular question. That as far as what was the standard, what was the SOP, there had to be an immediate threat of death or great bodily harm to any of the officers. And the question I asked him was there an immediate threat of death or great bodily harm to any of the officers, and he said no, there was not. And that was his testimony, and so it would have been improper to act in self-defense for even another officer if there was no evidence of immediate risk of death or great bodily harm to any of the officers. And that was his testimony, Judge.
And Your Honor, I just add for the record that the UJI does not include the word immediate.
Do you have, can you point anywhere in the transcript? It sounds like you got a transcript of the testimony to support your contention.
We only got portions of transcripts. We got transcripts of his cross-examination from Mr. Bregman.
I wasn't going to rely on you.
voluntary manslaughter instruction. And here, let me read what the footnotes of the voluntary manslaughter instruction say. Under these instructions, the defendant should be acquitted of second-degree murder if the state fails to prove beyond a reasonable doubt that the defendant did not act as a result of sufficient provocation. At the same time, the defendant can be convicted of voluntary manslaughter without the state bearing any burden of persuasion with respect to provocation. That's right in the notes to the UJI for voluntary manslaughter, Judge, which is 14-220.
I'm going to take 5 minutes to review my notes on Mr. Noble, and so I'll be back